It's a pleasure to be here. I feel like I'm at home when I'm in the Upper Peninsula. My heritage is from the UP on my grandfather's side. My great-grandfather came to Crystal Falls in 1893. My grandfather was born there in 1913. My grandmother was born in Rudyard in 1918, and my dad was born in Newberry. Nonetheless, I was born in Tecumseh, and my grandpa said, no matter the heritage, I'm still nothing more than a flatlander or a beat lifter. I'm so glad to be here today. I am the volunteer director of the Interstate Informed Citizens Coalition. We're a bipartisan energy policy advocacy group. We're involved with people living inside industrial wind developments all across the state. It is a volunteer position. I don't receive any salary from the IICC, but in my normal line of work is I'm a general contractor. But through the course of my volunteer work, I've been able to testify on energy policy in front of both the Ohio and Michigan Senate and House Energy Committees, as well as in Kentucky, and I've also testified in front of members of Congress in Washington, D.C., all on matters of land use policy as well as energy policy. So I'd be glad to share some of my thoughts and some of my thinking on these issues. Whenever wind turbines are discussed, there's always a turnout like this. And I love to say that wind turbines are easy to accommodate in a community and don't bring any social upheaval. Sadly, since 2008, we see that wind turbines are a very divisive topic everywhere they go. So what you may be experiencing here is not unique. I have a degree from the University of Michigan, but then again, so does the Unabomber. I'm the former vice chairman of the Riga Township Planning Commission, which, if we look at our portable map of the Lower Peninsula, is right down here, about 20 minutes from Toledo. I worked drafting land preservation policy for Lenawee County, and I also helped create a zoning ordinance for utility scale wind energy that was later added to the list of state model ordinances. There's a whole range of ordinances there. Some of them are quite restrictive, some of them are quite permissive, but the state did publish that list, and I was pleased to see that our township ordinance made it on that list. A couple of caveats: I am not a lawyer, even though I do watch Law and Order. Nothing I say today should be construed as offering legal advice. And I would say developing wind energy ordinances that can withstand legal scrutiny is a specialty. It is important to retain experienced counsel in these matters, and if you're interested in finding a number of different lawyers who are good at this stuff, I'd be glad to recommend some to you. Secondly, I would say, or firstly, as a former planning commissioner, I fully understand the pressure of being asked to say yes or no to a given wind development. It is a thankless task. And when we sign up for these jobs, we don't anticipate ending up in such controversial issues. But nonetheless, that's what stands before us. The good news is, I believe that reasonable wind energy zoning, driven by the principles of consent and compensation, can place the burden of deciding whether a given community hosts utility-scale wind development upon the wind developer and the citizens, rather than the zoning authority. And I think you'll see as I talk, that's the way it should really be. A couple things have changed. In 2008, when wind first came across my desk in Riga Township, there was very little wind constructed in the state. People had a lot of ideas about what it might be like, both in terms of economics and environmental impacts, as well as the land use policy impacts. We had to reach out to people in the thumb to learn about wind energy stuff, because there, except for the couple turbines in Mackinac City and the one in Traverse City, there really wasn't much wind in the state. We passed a law in 2008 called PA 295. It had bipartisan support and was pushed primarily by Governor Granholm. They required that 10% of our electricity in the state of Michigan be generated from renewable sources by the year 2015, and those sources had to be located inside the state of Michigan. So what we heard from wind developers was, the state says we have to build it here, you have to create a place for us. We've learned something since then. The Seventh Circuit's Judge Richard Posner has declared that Michigan cannot, without violating the Commerce Clause of the Constitution, discriminate against out-of-state renewable energy. So it turns out that clause in PA 295 that requires wind to develop only inside the state is not legally binding. Now, nobody has challenged it in the state yet. It still is the law. But we believe, and a number of other, including groups like the Clean Energy States Alliance, does concede that it's not legal to force that renewable energy to be built only inside the state. We've learned some other things. We now have over 1,000 megawatts of wind energy installed. And initially, the state recommended 1,000-foot setbacks from homes and 55 decibel noise limits. Now, one of the architects of these setbacks was a gentleman named John Sarver, who was in the Michigan Energy Office. And you'd like to think there was a lot of science behind how they picked these noise limits, but what Mr. Sarver said at one of the wind working group meetings was They knew that a casual conversation was at about 55 decibels, so they felt that people should not have to shout in their yards to be heard over the noise of the wind turbines. There was no question about low frequency noise or sleep deprivation. It was strictly based on whether or not you'd be able to have a conversation in your yard. We've learned a lot since then. Experience has been a very harsh teacher. Almost every place in the state that has widespread utility scale wind development is having a host of problems. We've had recalls, referenda, lawsuits. Upley, Michigan, 19 families brought suit against one of our early wind projects. They achieved a settlement in Ludington. 18 or 19 families are suing there as well over noise. It happens throughout the state, and you certainly have your share of issues here in Garden. It's not unique. It's happening everywhere. And as you know, I believe a couple of years ago there were a series of people living inside the turbine development in Garden Township suggesting that the noise has really become quite bothersome. Michigan has learned from this experience. Last fall they released a report on the status of renewable energy policy in the state of Michigan. And while it said it may be theoretically possible to reach 30% renewables in the state, there's a number of significant hurdles to reach to get to that number. And they're not sure it's actually feasible. They're now referencing some studies and papers in that report that suggest that 1.25 mile setbacks and noise limits below 40 decibels are likely necessary to protect people's health and sleep from wind turbine noise. We've also learned another thing economically about wind energy. Is wind energy available to any given turbine is equal to the cube of the wind speed. So if you see in Michigan, we don't have much wind above 6.5 meters per second at 80 meters. If you look at our peer in Iowa, they have a lot of 8.5 meter per second wind energy. What that means is every turbine that you build in Michigan could produce roughly twice as much electricity if it were built in Iowa rather than Michigan. Our average power purchase agreement price for wind generated electricity in Michigan is about $79 a megawatt hour. We can buy it from Iowa in the low 30s. So our wind in the state of Michigan is far from a bargain. And you see, that's why they wanted that in-state mandate to make wind possible here. Without the force of law, it's very hard to get anybody to buy the electricity. And some people suggest these new taller wind turbines that we're seeing, the latest ones we've seen being constructed are 494 feet tall, but NextEra has submitted a proposal to the FAA for Sanilac County for 590 footers. So the next generation is already on its way. But you see the yellow line is Midwestern wind and the purple line is Minnesota and Iowa. And no matter the state of technological advancement, our wind is always more expensive. Low wind resources, turbines cost more to install, and our power purchase agreement prices are significantly higher than the West. If you really like renewable energy and you want a lot of wind energy in our mix, then wouldn't you rather have 2 or 3 megawatt hours for every dollar spent than just 1? Finally, if you're very concerned about coal emissions, and the EPA has done some new things along these lines, our group is agnostic on CO2 and so forth. We have Democrats, we have Republicans, some who believe in global warming, some who don't. But if you're really concerned about global warming, then you need to consider this. We've spent $2.5 billion on wind plus transmission in the state of Michigan so far. At most, we've reduced coal emissions by perhaps 4%. Had we spent that same money on combined cycle gas turbines, we could have closed half of our oldest and dirtiest coal plants already. We could have slashed our emissions of fine particulates and mercury by about 50% and CO2 by 25% instead of only 4% at best. So it's a very poor environmental value. And if you don't like nuclear energy, can you replace the 1100 megawatt Fermi 2 power plant with wind? Well, I guess theoretically it's possible. If you fill that semicircle from Toledo, Detroit to Ann Arbor, every square mile with 2 1.8 megawatt Vestas V100 turbines, you could equal the annual average output of Fermi 2, but you would still have to build 2 500 megawatt gas-fired generators as well, because in June, and July, and August, as Irene Dimitri of Detroit Edison once said, their wind output is one fat goose egg. So wind is intermittent, it's variable, and you need to have dispatchable generation there all the time. Secondly, 36 square miles of this, like we might see in Ludington, those turbines, those 56 turbines in Ludington, the output annually could be produced by this semi-trailer mounted simple cycle gas turbine you could hide inside your average dairy barn. So there's a question of land use intensity and scale here that's pretty profound. The 14 turbines in the garden, maybe over an annual average, work like essentially an 8 megawatt generator. To give that a sense of perspective, we use about 12,700 megawatts of energy in the state of Michigan annualized over a year. So it's a tiny, tiny sum. But enough about the energy policy. I bring that up not because it's particularly land use related, but you often hear these arguments at zoning hearings saying because we're going to save the planet, because we're going to reduce emissions, we have to let these things in. Well, then we have to have an answer, and we have to ask the question at what price, and to see whether or not we really think this is a viable technology. But now let's talk about the land use issues in particular. How do we evaluate any product or any zoning proposal brought before us? We evaluate things roughly along the terms of total cost of ownership. And to establish an accurate total cost of ownership, we need to know the price and then evaluate the benefits and costs, etc. And that's pretty easy with a car because we all own cars, or know people that do. And we know a lot about them. We've had a long, common, familiar experience with automobiles. We have our ideas about 4 doors or 2 doors or SUVs, Japanese, American, German, and then we do the math. How much do I want to spend and what will I get in exchange? It's easy because we know all about cars. But when a wind developer shows up and says, we would like to build some 100-meter class Vestas V100s, we now have to ask questions about an unfamiliar product. Like, how tall are they? Well, the ones in Ludington are 476 feet tall. But just how big is that? Well, most of us don't have a sense of scale. I'll give you a hint. There's only one building in the state of Michigan taller than 476 feet, and that's the Renson. But there is one other structure that's that size that we're all familiar with. And so the new turbines now are nearly as tall as the towers on the Mackinac Bridge, and the latest batch that are being proposed will be even taller. And what do they look like in close proximity to your home? This is the Schindeldecker residence in Ludington. They're friends of mine. That turbine is 1,139 feet to the house. It's a 476-foot turbine. He and his wife now live in the basement, and on the windy days take sleeping pills and have a couple beers to go to sleep. Their 2 sons, one who was at Northern, the other at Central, came home for spring break this year, and they tried to stay at home, and after the first night they said, we just can't do this. We've forgotten how noisy it was. And that's pretty sad when your home is no longer a sanctuary for your own children. So, we're confronted with a zoning proposal for utility scale wind energy. Where do we go for guidance? When this first came across my desk in 2007 or 8, it was all new to me. I was a fairly new planning commissioner. There's lots I didn't know. But it turns out we have a guide, and it's called the Michigan Zoning Enabling Act. And experienced zoning commissioners will know about this. And it's very simple. A zoning ordinance shall be based upon a plan designed to promote the public health, safety, and welfare. Put it another way, if the proposed activity cannot be performed in our communities in keeping with health, safety, and welfare, it should not be permitted. Remember, a developer, and I'm not singling out wind developers here, a developer of any stripe, their primary commitment is to bottom line and to maximize their return on investment, and their recommendations are designed to produce that effect. But planning officials' singular and sacred commitment must be to health, safety, and welfare. You are the only line of defense between developers of any stripe and the interest of the community that you are representing. Now, what are your legal limits to zoning? We were very troubled by this in our township because the wind developers we were dealing with, one was a Fortune 100 company named Exelon. And they were flying their experts in from all across the country, and my little township of 1,100 people were not used to that kind of activity. So we're like, well, how far can we go? What are our rights under the law? And we were lucky to see 1 or 2 houses built a year and virtually no commercial development. This was all new to us. Well, it turns out that zoning regulations must simply have a rational relationship between protecting health, safety, and welfare, and they must not be arbitrary or capricious. If the zoning regulation meets those criteria, it is almost unassailable in court. Remember, commissioners, reasonable zoning is very strong. I'll give you an anecdote. I think I referred to it later, but as we began to write our ordinance in Riga Township, and it was not pleasing the wind developers, they suddenly were flying attorneys in from Colorado Springs and driving them down from Farmington Hills, and they were all telling us, you're writing an exclusionary zoning ordinance and we're going to sue you, and you're going to lose, and it's going to cost a lot of money. And they kept saying that right until we adopted a very strong ordinance. Then the people with the leases put that ordinance on the ballot through referendum, and the people who were not interested in permissive zoning prevailed 64 to 36%, and as soon as that took place, they left. They threatened litigation everywhere, and I know of no case in the state of Michigan after 2006, which was before the PA 295, in which a wind developer has ever sued a community over restrictive zoning. Could they? Of course. But they know that strong and well-conceived zoning is almost unassailable in court. The one case that I know of in 2006 was called Johnchek versus Bay Township, in which they had a township-wide zoning ordinance that restricted all structures to only 30 feet in height. And the wind developer wanted to build a turbine bigger than that, and they said, your ordinance is exclusionary. And the court said, no, it's not. You can build all the 30-foot tall wind turbines you want. Another question that comes up is, do we zone for wind energy in a permitted use or conditional use? And I heard some folks talking about special land use permits and so forth, overheard a little bit, so it's obvious some of you are familiar with these different types of uses. But if you give it a permitted use, then as long as they comply with the regulations under that process, then you have to issue the building permit. Under a conditional use or special land use permit, there are regulations there as well, but there are room for more public hearings, and you can demand more and make changes and so forth. It gives your commission much more flexibility on how to manage what frankly will be the most substantial construction you'll ever have in most communities. Now some communities say, why don't we just grant variances for everything that we want to use to let these projects go forward? In other words, write a very restrictive ordinance and we'll just give variances. Well, there's a real risk with that. Variances are a permanent license to break the zoning law. They're not a means to modify the zoning law. Secondly, variances must be derived from a unique hardship not created by the landowner. Just because somebody decides to do something that now puts them in violation of the zoning ordinance doesn't mean that you're obligated to grant them that variance. But if you have a side yard setback for houses of 5 and 10 feet on each side, and yet you have this in an 80-foot lot width, and yet you have this existing non-conforming lot that's only 65 feet wide, it may very well be acceptable to grant that particular hardship case a variance to go ahead and build, because it's a unique characteristic. But you have to be careful. Once you grant that variance, they're irrevocable. And even if you change your future zoning, that right goes with that parcel forever, in perpetuity. And they set a precedent. If you got 10 100-acre parcels in a square mile, and they're all largely empty farm fields, and you grant one guy a variance to site wind turbines on one parcel, you've just changed your zoning ordinance for everybody that has a parcel that complies with those same conditions. They don't have it automatically, but if they take you to court and they say, you gave this 100-acre guy a permit to build the turbines with the variance, you have to give it to me too, and you will. You would lose in court. That is my non-legal opinion, but that's the way things work. A variance should be a place of last resort, and it should be rare. You do not want to routinely hand out licenses to break the law. Back to health, safety, and welfare. Protecting health, safety, and welfare is our sworn duty. Developers of any type are crafty and present many superficially enticing arguments and promises, but protecting health, safety, and welfare comes first. So, a couple questions. Are the developers' profits more important than health, safety, and welfare? If you're uncomfortable with implying in your mind wind developers every time I say developer, say medical marijuana dispensary, or adult bookstore, or coal-fired power plant. It makes no difference. We all recognize there are a lot of objectionable uses we don't really much care to live next to. So you can fill in the blanks any way you want, but are those developers' profits more important than health, safety, and welfare? Are promised increases in tax revenue more important than health, safety, and welfare? Are claims of private property rights more important than health, safety, and welfare? And are claims of green jobs or emissions reductions more important than health, safety, and welfare? And the answer is simply no, they are not. The Zoning Enabling Act says those things must come first. Remember, it is the health, safety, and welfare, not health, safety, or welfare, that commissioners are duty-bound to protect. Too often, health and safety are diminished in exchange for promises of jobs or tax revenue welfare. But those developer promises are not binding contracts. So, here's the things I am going to talk about. There are many things that we can talk about with wind energy regulation. The list of things you might want to regulate could be 30 or 40 items long. There's only a few that really are substantial and that have the biggest impact. So, in the interest of time, I'm going to focus on them. Nobody wants to sit here till midnight. So I'm going to talk primarily about setbacks, noise, and decommissioning, and then a little bit about a few other issues. So we have to figure out who do we trust on setbacks. And I try very hard to find sources that are hard for anyone to accuse me of picking biased anti-wind sources. Because what's the point? Anybody can play that game. The Vestas is the second largest turbine manufacturer in the world after General Electric now. Their health and safety instruction for their largest turbines say, if a runaway operation should occur, the plant must be evacuated immediately by running upwind, and access to the surrounding area in a radius of at least 500 meters must be restricted. That's 1,640 feet. Nordex says the same thing in the event of a fire. And in real life, we see this 390-foot turbine in DeKalb, Illinois did explode, and my friends there report to me the debris field was about 1,500 feet. So these guys have a pretty good idea of where the debris is going to, how far it could theoretically go. Now, what most wind developers are proposing is a 1,000-foot setback, maybe 1,320, to the corner of a non-participating house, even though it's 320 to 640 feet less than the manufacturer's recommended employee evacuation zone, which means in the event of a fire, the employees might theoretically have to run upwind 600 feet past your house. Now, presumably they would knock on your door and warn you about the fire on the way through, but that doesn't strike me as reasonable. Even if you move that setback back to the house, you now see that this no-contract farmer, because the setback is to the corner of his house, has just given away his future development rights to the neighbor in exchange for nothing. That doesn't strike me as reasonable either. And Foster Swift, the law firm we use in Riga Township, they made a strong case that the noise limits and the setback should be based from the property line. All other land use regulations are derived in the same fashion. And why would you give your neighbor's property away for free by zoning ordinance? Moving those setbacks, physical safety setbacks to the property line allows both people to do everything that they want to do on their property. People say, but I have a right to do whatever I want on my property. And I agree with that up to a point. And Oliver Wendell Holmes said, the right to swing my fist ends where the other man's nose begins. My corollary to that is, if my development project requires me to repeatedly punch you in the nose, I should first get your consent and then compensate you for your broken nose. What Riga did with setbacks was a compromise. We chose 4 times the height of the turbine to a non-participating property line and a quarter mile or so to a participant's residence. And the larger setback could be reducible by a waiver or basically making them a participant in the project. In the view of what the state of Michigan is talking about now with 1.25 miles, which is pretty consistent with the data I've seen on low frequency noise, 10 times the height, it might be more in order, and 1640 to participating homes. Frankly though, if you want a turbine on your property and you want it 1,000 feet and you're willing to sign away your right to that, I mean, I would not stand in the way of that, but I think the neighbor who's not signing a lease should be protected. Another thought is use a multiple of the turbine height, because when I first worked on our zoning, they were 390 feet tall. Then the next ones are 494 feet tall. Now the next ones are 590 feet tall. If you have a fixed height, but yet they double in size, that thing is arbitrary. And then secondly, if somebody decides to litigate and you have a multiple of turbine height, you're in a much stronger position in court, because they say, I want to build a 500-foot tall turbine and 10 times the height is a 5,000-foot setback, and that's ridiculous. And the judge can say, yes, but a 50-foot tall turbine, you can get a 500-foot setback. So there's no way that can be construed as exclusionary. It gives you a very strong position in court. Again, property lines are critical. In my opinion, the bottom line is most important. Wind projects should not require non-participating landowners to donate their property to the wind developer as a safety and nuisance easement. That strikes me as unjust and unfair, and that's where the bulk of the issues of wind development projects take place in our communities. The waiver is the key. 2-stage setback is what empowers your residents to negotiate on their own behalf with the wind developer. It prohibits wind developers from leasing in a checkerboard fashion, and they often do that. You generally think they're trying to lease your whole township, every last section. Truthfully, they're only looking for a few parcels in any square mile, just enough to get the turbines built without involving anybody else in the project. By giving that large setback to non-participants, it requires them to negotiate with everybody who's going to be impacted by the wind development. That just strikes me as eminently fair. Again, they will say that's exclusionary, and the Michigan Zoning Guidebook says you cannot write exclusionary zoning language unless there is no appropriate location in the area to provide for the use. Well, we define appropriate location by health, safety, and welfare. And as I've said to some wind developers, just because you want to shove a size 12 foot into a size 6 shoe doesn't mean I have to accommodate that. Unsafe is unsafe. And I won't read all this in the interest of time, but the Michigan Bar points out that, look, you don't have to accommodate every lawful use in every community. If your neighboring township permits, let's say, adult businesses, and it's right on the township line, you don't necessarily have to provide a place for that lawful use of land in your community. And so you can make that argument. If a neighboring area has a place for them, it's not necessarily exclusionary. There's a whole list of requirements that have to be done through. It's very hard to get a judgment of exclusionary zoning. I often hear the statement, if you don't let the turbines in, the state's going to take control of your zoning and you're going to have no choice. Governor Snyder's on record in Traverse City as saying he does not support preempting local control of wind energy siting. You can call his office and confirm that, and the legislature has no support for that either. Many Michigan counties and townships have written strong zoning regulations, and they have not been sued. And I've already covered this though. Now, back to the noise. Here's one of the most troubling things. How loud is too loud, and who do you believe? Well, let's start with the World Health Organization. The World Health Organization studies these matters, and they say, look, with 30 decibels of noise nighttime outside, no substantial biological effects observed. Between 30 and 40 decibels, you start to see some impact on people inside the homes with awakening, sleep disturbance. Most people are not going to be troubled too much, but young children and the sick might start to experience some more profound issues. 40 to 55, we start to see a sharp increase in adverse health effects. Exposed populations have to adapt coping mechanisms, etc. And above 35, we start to see some pretty profound health impacts. This is true in large cities with a lot of noise. I mean, the whole purpose of the World Health Organization recommendations is to protect us from another type of pollution, namely noise pollution. Now, how about we ask the American Wind Energy Association? Bob McConey is one of their lead authors and proponents of wind turbine regulations, and he says, look, 45 dBA outside the home would not cause adverse health effects. But when they got him on the stand and they grilled him, he said, look, if it was his home in the vicinity of a wind farm, he would want the noise levels to be kept below 35 decibels, something along those lines, maybe 40 is measured outside the home. Dave Hessler and George Hessler, father and son, are noise consultants for wind developers and other folks all across the Midwest, and they've participated in projects here in Michigan on behalf of the wind developers, but the state of Minnesota hired them to evaluate wind turbine noise in the state. And they said, look, based on the observed reaction to typical projects in the U.S., it would be advisable for any new project to attempt to maintain a mean sound level of less than 40 decibel outside all residences. And it says it's important to note that that doesn't mean that it'll be inaudible, and some people even still may be annoyed at 40 decibels, but in the vast majority of the cases, the problems are going to be reduced. Rob Rand, an acoustic consultant, looked at our township ordinance at 45 and said, look, all across New England they use 45 to 55 and it's full of litigation, complaints, and problems. It doesn't work. Vestas also said, and this is from their noise policy, Vestas recommends that government supplement relative noise limits with a low absolute maximum in areas of very low background noise. I don't know of any place more quiet than most parts of the Upper Peninsula, which ensures minimal noise disturbance for turbine neighbors also in these places. And I don't want to get too deep into this, it gets technical, and if you're really going to dig into this, you should hire a strong independent acoustical consultant. But LA Max is like a speed limit on the expressway. You go 65, 66 and a 65, they can write you the ticket. LEQ is an hourly average. Now, if you're doing 85 on US 2 and the cop pulls you over, you wouldn't get very far by putting your case and say, my hourly average, officer, was only 53, even though you caught me for a minute at 82. That's the difference. And you see, they play some tricks with this measurement because 25 decibels is incredibly quiet. And so some of these ordinances are based on not making the turbine noise more than X units louder than your existing quiet background noise. And so when they measure that, they like to do that over an hourly average. Well, here's the problem. 25 decibels is incredibly quiet, and they can record that noise reading for 59 out of 60 minutes, which would make you think that your nighttime noise level is about 25 decibels, and it is 59 out of 60 minutes. One car drives by for 60 seconds and raises that noise to 65 dBA for just those 60 seconds, and because of the way the decibel scale works, now your hourly average was just raised to 47.244, even though 59 out of 60 minutes it was actually only 25. So then the wind guy comes in and says, my turbines aren't going to be any louder than your ambient noise because they're 45 decibels and your ambient is 47. Yeah, except for 59 out of 60 minutes, it's really only 25. All that to say, you have to be very careful. Noise science is very complicated. It's above my pay grade, but you need solid independent help if you're going to go down that road. Ryder used a 40 decibel nighttime noise limit at non-participating property lines at night, and 45 daytime noise limits. Then we added a low frequency limit called 55 dBc for low frequency noise protection. I think that was a good compromise. Some will tell you 35 or die. I would say 40 at night is a pretty good compromise. Shadow flicker, some of you may not be familiar with this. I usually have a video of it, but it's the massive shadows that we're seeing extend out as far as a mile from the turbines. Happens certain seasons of the year. It can be pretty problematic. Look at the videos on YouTube. But they will recommend a 30-hour per year average of shadow flicker. But how do you ever enforce that? Somebody would have to go out at every home measure the flicker event when it starts, when it ends, make a log, and let's say you get through a whole year and you're at 37 hours and you file a complaint. Now is your zoning department or your building department going to send somebody out for a year to make sure they're telling the truth? I mean, it's very hard to enforce that law. They make modern software detectors and sensor packages now that will simply shut the turbine off for the 20 or 30 minutes that the flicker is an issue and then turn it back on. Actually gives the developer more siting flexibility. Technology is making it easier to accommodate some of these things. FAA lights, the turbines in Garden, there's 14, which is a lot to the people that live there. You go to Gratiot County, you see 100 and more, and it's a striking effect. The lights they make an effect, there's no question. There's now radar-activated FAA lights that only turn the lights on when the plane is approaching. I would recommend that you might include that in your ordinance. Property value impacts. The most prominent industry-funded studies suggest there are no statistically significant impacts on property value. This list of independently funded studies, both from universities as well as independent appraisers, have included anywhere from 15 to 59% loss in property values up to 3 miles away. The study you'll hear about most from wind developers is from a guy named Ben Hone from the Lawrence Berkeley National Lab. And people, the wind developers brought those to they bring them to every meeting. Here's the study. See, there's no impact on property values. Well, there was a phone call with the author of that study. He said, look, we are very cautious about what happens close to the turbines. We don't really know what's going on there within about 1,250 feet. Well, guess what? Most turbines are within 1,250 feet of a person's house. So you might know about a property value guarantee, Hone says. It's a dicey situation, complicated, but I think homes that are very close, there is just too much unknown right now. I think one of the things that often happens is that when developers put our report forward and say, look, property values aren't affected, and that's not what we would say specifically. On the other hand, they have little ground to stand on if they say we won't guarantee that. In the special use process application, I don't think it would be out of bounds to ask the developer to offer a property value guarantee, but we cannot require it because it could be defined as a tax, and you don't have the ability to levy a tax through zoning. But nonetheless, any responsible developer, if they believe there's no impact on property values, would be happy to offer them. Decommissioning matters. These are the turbines in Hawaii. Developers will often tell you that you can just cut them down for the scrap value. It easily covers their expense. Well, if that's the case, why did they cut them down in Hawaii? I mean, the scrap value is standing there. I heard a wind developer in Ogama County say, oh, it's easy. You loosen the bolts, put dynamite on the side, they drop like a tree. Well, I got to tell you, nobody takes them down like that. And the cost I've seen are about $250,000 a turbine to take them back down. You want decommissioning language in your ordinance. What we came up with, and it's not ironclad, is that you require decommissioning and that they post a bond with a bonding company, that the value for that bond should be determined by hiring an independent engineer to determine the value to remove those turbines and whatever portion of the base you want removed, and that the county or the township get to select the engineer and the developer pay for it. Developers often recommend a financial guarantee instead of a bond. We don't recommend that, and here's why. NextEra Energy is the largest wind operator in the nation. They did a financial seminar of theirs, so they left these things on the internet. They point out the majority of the earlier economics for wind projects are tax benefits, and that's true. NextEra pays almost no income tax, despite owning a massive fossil fuel generation fleet because of the largesse of the production tax credit and other maneuvers. What's my point? Since the bulk of the economic value to that principal initial partner comes in the early years, it means the people you're negotiating with today are not likely to be the same people that own the project 10 or 15 years down the road. I think on average they last 6 or 7 years before they change hands. You can look it up, it's called the Minnesota Flip. There's a lot of arcane stuff there, but Michigan's oldest substantial project in Nutley is on its 3rd owner since 2007. Wrapping up then, most land use changes are pretty benign. You want to change your side yard setbacks for residences from 8 feet to 5. Some people say it's too close, but in truth, it's not that drastic of a change. Wind turbine impacts are disproportionately large just because of their scale. We felt in Riot that the change of land use policy was so massive and the impact so profound they should not occur without consent and compensation to all parties bearing the direct impacts. 2-stage setbacks with a waiver option for both noise and distance require the developer to negotiate with all impacted citizens. It is fair and equitable and prevents community division. Conditional use permits give zoning authority maximum flexibility in protecting health, safety, and welfare. Now, commissioners, has anyone ever come into your commission and said, the light coming through my windows is too steady, could you make it flicker? Has anybody ever come in and said, it's too quiet in my backyard, could you raise the noise to 55 decibels from 25? Or my property values are too stable, could you build some 50-story industrial machines next door to put that value at risk? Of course not. There's an unwritten rule of land use policy, and it's this: we were here first, we get to decide. Secondly, developers will never have the right answer to the questions of health, safety, and welfare when their paycheck depends on not knowing the right answer. The acoustic consultant that came to my township said that a quarter mile setbacks and 45 decibels would be perfectly safe. And then we found his testimony about another wind project when the community group had hired him instead of the developer. He said similar turbines would cause a problem up to 1.25 miles away. Now they both can't be true at the same time. He that pays the fiddler gets to pick the tune. In the end, there are only two types of wind ordinances. Wind developers ask communities everywhere to essentially adopt language that gives them free safety and nuisance easements across non-participating parcels. I think reasonable wind zoning demands that those easements be negotiated individually and privately between the developer and the impacted landowners, rather than forced upon them by zoning regulation. It also eases from the zoning authority this burden of knowing that maybe this percentage of the people in my community want them, this percentage don't. How do I ever cut the baby in half in a way that everybody is pleased? Put that onus back on the developer. If they want to sell the project, let them buy their way in. That's the only reasonable way to do it. And frankly, if they buy everybody in 6 or 8 or 10 square miles, who's anybody to stand in the way? The democratic voice of the people has spoken. And I've already said that. So, this is in DeKalb, Illinois, giving you an idea what these various setbacks look like. So I'd be glad to answer any questions. Yes, sir.
You have a question of bonding to pay for this decommissioning. What happens if they don't pay for the bond, and what happens if they go bankrupt at that point? Does that fall on the community to pay the bond, or does the bond just expire?
Bonding is not ironclad, as I try to suggest. They will fight, the bonding company will always fight to pay out, frankly. It's never going to be simple, it's difficult, and you're right, there's all kinds of pitfalls that are associated with that. I don't have a clear answer on who, it'll all depend on the nature of the bond, how it's structured, and who covers that stuff. At a certain point in Riga Township, I think we realized with an annual budget of only a couple $100,000 versus Exelon, a Fortune 100 company, we would never have the financial means to enforce our ordinance no matter how we wrote it because of risks exactly like that.
Wouldn't you require an escrow to the county to say cover 3 to 5 years of the bond?
That can be done as well. You can write all manner of those things in there. I can tell you, all those things are reasonable. I can tell you the number of them will become a non-issue right away as soon as you just tweak a couple parameters, because they just will never agree to terms other than what they're asking for when they show up. If you're not going to give them 55 or 50 and 1,000 or 1320, and you try and go anywhere above that, all these other things are important questions and reasonable, but they're never going to come into play. They will go to another community.
But if inflation drives the price of decommissioning double to what it is, your bond still isn't going to cover it.
That's
and
right.
That's going to fall on your township, your community, and the landowners that signed the lease.
Absolutely, which is why I think RIGA has required an adjustment for inflation. But it's a problem. Exelon was willing to do that with us in our community, but yet Exelon actually built in the thumb, and Exelon has now changed the name of their wind company to Continental Wind because we think they're going to get out of the wind game, because Exelon is in DC fighting against any extension of the production tax credit for wind, which is what makes these things fly, because it's hurting their nuclear fleet for a long discussion that we don't have time for here. All that to say, Continental Wind is now in Huron County saying we want out of the bond, we just want to offer a financial guarantee. And I think it's hard with the decommissioning bonds and stuff in place for them to sell the project. So yes, you're right. I think all those are legitimate concerns. You would have to negotiate that with a sharp lawyer and a good bonding company.
One more question. You spoke of a referendum. There was one in Huron County, wasn't there, that put up, what does that do for our community, or how do they go about that?
There have been several referenda in Huron County. There have been referenda all across the state on wind. First of all, many communities will say, why don't we just put this on the ballot and see if people want it or not? Well, you can't put an opinion question on the ballot. You have to make a change to your zoning law, and then if the people want, they can submit paperwork to put it up for referendum. Huron County had 2 township referendums where they adopted one permissive wind zoning and one restrictive. And both were challenged by the people, and the permissive zoning was defeated 61 to 39%. Paris Township supported strong zoning of by about 64 to 36%, somewhere in that same range. There was one wind referendum in Huron County that did appear to permit more wind to be built, but it wasn't a zoning amendment, it was a wind overlay district, saying how many of these townships will be inside this wind overlay district, and the people put that on the ballot. Only 4 townships, maybe 6 out of 14, had any immediate threat of getting wind development in their community, but yet all 14 got to vote on it, and that wind overlay district increase was approved. But since then, the townships that have had a chance to vote have voted against it. But there have been some dirty tricks played there. In Brookfield Township, 4 out of 5 commissioners or trustees have signed wind leases with NextEra Energy, and they wanted to give their zoning to the county because it was permissive county zoning, but they didn't want to have a conflict of interest to change their own zoning, so they just voted to get rid of township zoning altogether, letting it default to the county. People put that on the ballot, and by 1 vote, prevailed in preserving the zoning in their township. In the next meeting, the people voted again to just toss it overboard and give it back to the county. It's in court, but the turbines are going up. I'm telling you, this can be a very dirty, dirty game. Why is there wind in Huron County? I'll tell you why. The majority of the planning commissioners and county commissioners at the time the ordinance was adopted had signed wind leases. That's what takes place in most places across the state. Yes, sir?
With the windmills similar to those that are in Garden, do you have an estimated cost per unit that those things really run? And what is the offset of those, the credits and rebates that the developer gets to use?
The install cost for wind in Michigan is quite high relative to our regional peers. Michigan's turbines cost somewhere between $2,200 and $2,500 a kilowatt to build, which is about 2.2 to 2.5 million per megawatt. So you're somewhere between 4 and 5 million for, I think, those 2 megawatt mesas. And so that's roughly what those are costing to build. I think those turbines in Garden are running just under or just around the 30% capacity factor. The numbers I've seen is that the bulk of the revenue, like the slide I showed from NextEra, to the developer is in tax avoidance, and it's not directly the energy sales themselves. But in the case of Garden and some of the other earlier wind lease or power purchase agreements, they locked in really quite a high price for the energy, well over $100 a megawatt hour. You can understand the wholesale value of electricity in MISO is about $28 a megawatt hour. And worse, MISO's independent market monitor, Potomac Economics, said that wind in MISO, in our region, is sharply inverse to demand. And so what that means is wind is most abundant, as the people who live there can tell you. It's not in June, July, and August. It's most abundant in the fall and in the spring and at night, when the price and value of electricity is really low and demand for it is really low. So it has a very high cost and a relatively low value. And both Dr. Josko at MIT and Glenn Schleedy have written papers stating exactly that. And in fact, that paper was submitted to the state, and they have adjusted some of their statements in their report on renewable energy as well. But it's a very high cost, very low value. And secondly, there's a really good paper that came out a couple weeks ago by the Brookings Institute, which is center left. And the whole paper was about how to cost effectively mitigate emissions for CO2 and anthropogenic global warming. And they said wind and solar are the 2 most expensive means of reducing CO2 emissions. The gas and nuclear are far cheaper. Another question? Yes, sir.
I called Washington yesterday and spent about 3 hours on the phone just wanting, had one question. Is the wind subsidy that the government's given out over $22 billion since its wind farms have been developed, and it expired 12/31/13. And according to the U.S. Department of Environment and Natural Resources, it's still out of committee, but the lobbyists are really pushing to get it renewed, and not only get it renewed, but make it retroactive. So obviously, if they don't have a big subsidy, there's not going to be a lot of wind turbines built.
When the PTC expires, wind construction largely stops. It's $35 a megawatt hour in value pre-tax. And we know that's the number that they're valuing at, because in Texas and ERCOT, whenever the price went to below, remind you, wind guys are paying the grid to take their energy at certain times of the year. So the wind guys would keep producing energy until the price hit minus $35 a megawatt hour, because that was the trigger point where they're no longer making anything. So remember, the wholesale value of electricity on average is around 30 bucks, so they're receiving a subsidy that's roughly equal to the wholesale value of the product they produce. Now, it's true that gas and nuclear and coal also receive some subsidies, but in 2010, during the stimulus package, wind was receiving $53 a megawatt hour in total subsidies, while gas and coal were getting 64 cents. So it's very disproportionate. Now again, you may argue that that's worth it if you're building 100 turbines and you're shutting down a coal plant. But the truth is we built 1,000 megawatts of wind in Michigan, and with the exception of Harbor Beach, which is closed because of access to new transmission lines, our coal plants have thus far have not been closed because of wind. We are having coal plants that are being closed, but it's not because of a high penetration of renewable energy. That's EPA regulations and MATS rules and so forth. Yes, sir.
What can Garden Township do now that they've already got these turbines down there?
That's a tough question, but you are not without recourse. Like any other permitted zoning activity, if the zoning that you created permitted an activity that turned out to be a nuisance, you still have ability to regulate that. It's not grandfathered in. Impacts of health, safety, and welfare can still be regulated. Now, you can't change the zoning. You can't make them move a turbine location. But Garden Township could write a police power ordinance that simply says between the hours of 10 p.m. and 6 a.m., the noise of any type of industrial activity, you'd have to be cleverly crafted, you want solid counsel. But you could actually write an ordinance now that they would be forced to comply with. Would they sue? Absolutely. Would they win? Not sure. I'm not a lawyer. But townships and not counties have the legal authority to regulate nuisance activities. The county does not have the authority, according to Jennifer Granholm's Attorney General's opinion, to regulate noise countywide in a nuisance feature. So yes, Garden Township would have options, legal options, and then you would want to make sure if you decide to do that to check your liability insurance policy and see if you have coverage. Most every community's liability policy would cover them for millions of dollars of exposure to litigation. But you have the ability to protect your residents from harm, from anybody. Any other questions? Yes, sir.
Does the wind turbines have any effect on groundwater and the wildlife?
I'm not so sure about groundwater. It depends on the depth of your aquifers and so forth. It's not a subject I've studied a lot. We know that the Fish and Wildlife was on strong record in the Garden Peninsula project saying do not build because of the 3-mile shoreline setback for migratory waterfowl. I mean, that's clear. And Fish and Wildlife knows far more about it than I do. That's not my strong point. But Garden should not have been built had they followed the guidelines of Fish and Wildlife. Now, as far as deer and so forth, I've heard various things. To me, they strike me as speculative. Could it drive the deer herd out? It could. I don't have any direct evidence on that. I've seen some studies about low-frequency noise causing minks to eat their young. I don't want to go down that road. I don't have enough solid evidence that I find credible. Yes, ma'am.
I'm interested in the same question, but horses are my thing. We built a horse barn. Still don't have a horse in it because I saw a study come out of Portugal vet school in regards to deformities, and it showed pictures of deformities in the fetlock foot of young horses. Mm-hmm. They did autopsies and investigative surgery. The wind farm there, they also did some tests on the vibrations coming off of the wind turbines. They thought what was happening was that the collagen in the bones was developing at a different rate that the soft tissue was around it, such as tendons, which then made the hoof curl under. And they had no deformities before the study. And when the wind turbines went online, then the deformities began. They tried testing, like taking horses away. They found that they improved. They tried importing horses that had maybe no genetic background to the rest, and they developed the same symptoms. So basically the research from that vet school then says more research needs to be done. I'm not going to use my horse as a guinea pig. So now I'm profoundly impacted in how I want to do my life because of being in the garden wind farm.
Yeah, like I say, I've seen some of those studies. I don't have enough personal experience with it. I know if you write zoning that protects human beings, then nobody will have those kinds of impacts unless they consented to it. And to me, that's the safest way to do it. I mean, I've heard all manner of claims of impacts, and I stray voltage and so forth. I thought that was nuts. And I talked to a guy who's actually observed it, and I thought, well, okay, this much I know. The World Health Organization, State of Michigan, a number of reputable sources are pointing to we know the trend over time is to make stronger and stronger setback. Because as more people have turbines installed, the wind guys are going to some very low wind regions now, and I think one of the reasons is because it's so hard to get them built in communities where the people have a say. Like I told the Schindeldeckers, I said, you know, if the 56 turbines in your community shut down 1,000 megawatts of coal somewhere, we could argue that that's a proper societal trade-off. That, okay, we have these health impacts, but we have this benefit and it's worth it. But that's not what happened. But secondly, if that really happened, consumers who got a $73 million check from the stimulus program to build those 56 turbines, they could have just bought the houses out. The people who oppose that there allegedly cost consumers about $3 million, and it turns out you could have bought the homes for all the litigants for that amount or less, and just made the problem go away. That seems reasonable. Rob Rand, the acoustician, used to do noise control design for gas-fired generators, and the operator of the gas plant would say, how much protection to the neighbors can I get for X amount of dollars worth of equipment? And they would give them a price. And what he testified in Ohio was very compelling to me. He said, the average cost for reducing the noise output from a gas plant is about 10% if you want to be very good acoustic neighbors to the people living around the plant. And he did the math on the Van Wert County turbine cluster in Ohio and said, look, inside the 40 decibel contour, for 10% of the cost of constructing that project, you could have removed everybody from outside that 40 decibel footprint. It's not an outrageous burden to bear. Anybody else? I don't want to stretch too late. I guess another gentleman's going to speak. Yes, sir.
Yes, in your use with land development, have you come across any information on building offshore wind turbines?
Well, I mean, I don't know whose jurisdiction that would show up under anyways, probably the state's. I don't think there's any support in Lansing for offshore. They're trying again to get one going in Lake Erie. It was canceled. Now there's some sense that there might be life breathed into the thing. I know Governor Granholm suggested maybe they'd be mounted on barges and floated around the lake to various areas. My brother said, well, then why not just put a nuclear propulsion system on, you could drive them around the lake and generate the wind as you went. I mean, at some point it's a little silly, right? I know that the offshore wind costs are 2 to 3 times the price of onshore, and onshore is already significantly expensive. So, anyone else? Okay, thank you so much.